Hello everyone. This is Raghav Parsarthi. I'm an advocate practicing in Bangalore. I welcome you all to this video on real estate and consumer rights. I would like to thank the Center for Environmental Law Education Research and Advocacy for organizing this short video. And I would also like to thank the Department of Justice, Ministry of Law and Justice for granting this project on Pan-India Legal Literacy and Legal Awareness Program. Now let's try to understand the nuances of the real estate and consumer rights in India. Before we jump into the actual aspect of the consumer rights, let's try and understand the genesis, which basically commences the issues or the problems that a particular person or the allottee may face when he books an apartment or a residential complex under the real estate laws. Before we jump to that, let's try and understand what exactly do we mean by the term real estate. The term real estate is basically consisting of land and building, right? But this is the simplest form of definition that I can explain to you. But the Niti Aayog has come out with a definition which basically means the land, particularly the air above it and the ground below it, and any buildings or structures on it, which can be used for different purposes, including for residential, commercial, retail outlets, industrial buildings, so on and so forth. So the Niti Aayog has specifically defined what exactly do we mean by the term real estate. Now, what are the laws that are prevailing or governing this particular area or the field of real estate? Prior to the year 2015, only few of the states, including Maharashtra and West Bengal, had a law on the regulation of real estate in their respective states. Whereas the other states, including the state of Karnataka, did not have one. So what did the government do? What did the central government do? Excising the powers to enact a law for the purpose of governing real estate, the central government, invoking several provisions under the constitution, they basically drew up the real estate and regulation law way back in the year 2007-2008 itself. Subsequent to that, sometime in the year 2012-13, when the law got tabled in the parliament for the first time, there were several recommendations, several changes which it required. So that's the reason why it took some time for the law to get passed, and only in the year 2016 that the Law on Real Estate Regulation and Development Act of 2016 came into picture. But prior to this, the law on real estate were basically governed by different prevailing laws, which included the Transfer of Property Act, which included the municipalities, municipal corporations of the respective states, and also the Land Revenue Acts. Well, when the aspect of real estate is being governed by so many different legislations, there was a need felt that the government must intervene in this particular issue and enact a suitable law for the protection of consumers and for the welfare of consumers. Well, there were several issues that the consumers or the allottees faced when they booked an apartment or a residential flat or a house for that matter with a builder, and the builder created a lot of issues which included basically the handing over of possession or probably lack of amenities, so on and so forth. There will be multiple issues which each of the allottees will face, and it depends on a case-to-case basis. Let's now try and understand the genesis of this whole dispute. When we are trying to understand how the transaction happens, it is basically when any person, as a layman, if I have to understand how the real estate transaction basically works, it is just that if I am a person who is interested in purchasing a home or in need of it, I would immediately search for a house on probably multiple sites available on the internet, and based on that I would shortlist some of the houses which according to the preferences that I choose, right? So after all this, I would get in touch with the person who has basically developed the property, or who might have been an owner of the particular property. right? So we will only be focusing this particular discussion on the aspect of a consumer or an allotee from the perspective of purchasing the whole apartment or a house from the builder or a developer of those residential projects. So at the time of executing or the transaction basically commences when a particular person or when a consumer or an allotee books a flat and he signs the sale agreement, right? So this particular document, that is the sale agreement, consists of several aspects, which includes the consideration to be paid, the flat that you have booked, the flat intended that you wanted to purchase. So based on the representations made by the developer, the allotee or the consumer would have booked a particular flat. For this particular discussion, let me keep the flat as flat number 201 or something, right? So this particular flat number is also reflected in particular apartment complex, in the area that it is built, and in the particular survey number or the property number. As we all know, the property number basically gives the details about the project that is coming up. So all these details are the bare minimum requisites in the sale agreement. What other additional things are also are provided in the sale agreement? In addition to these points, the sale agreement also consists of making payment to the developer in time as per the schedule as fixed under the Real Estate and Regulation Development Act. In addition to that, making payments with respect to taxes. It could be with respect to payments to probably procuring some items or some materials which may have been fixed in the sale agreement itself, right? So basically the document of sale agreement basically provides the developer and the allotee with certain rights and obligations to which both of them have to adhere to, right? When this particular sale agreement is executed by the developer as well as the consumer, they will be bound by the obligations that are there in the sale agreement. In addition to that, the sale agreement basically also consists of the time stipulation within which the developer as well as the allotee is bound to execute and finalize the transaction and execute what we call as the sale deed. This particular sale deed confers the title, confers the right, and also hands over the possession to the intended customer who has booked a particular flat by making the payment as per the prevailing market rates or as agreed between the builder as well as the allotee. So what are the issues? What are the issues that a consumer might face? Suppose after signing the sale agreement, if the consumer wants to know the details of the transaction, wants to know in which stage the project is presently there, he will have to get in touch with the developer. But is that a right? Is there a duty on the developer to provide these information? Is there a right on the consumer to seek for these information? I would say yes. Under the Consumer Protection Act and also under the Real Estate Regulation and Development Act, if you refer to Section 19, Section 19 basically provides certain rights to the allottees. So, as in when we, or as an allotee, if I have to book a flat, there are certain preliminary work that I as an allotee will have to undertake, and I also have to do some basic due diligence which is required for me to understand that the project is clear of all the issues or there are no pending litigation pertaining to the land. So that is the reason why a due diligence is always important, and you can contact your lawyer to understand how the process goes about. In addition to that, once the due diligence is completed and once the allotee or the consumer is satisfied that the project is clear to be gone ahead and it is clear to go for purchase, then he will book the apartment with the flat that he is intending to purchase, in this case being flat number 201. And in addition to that, he will also sign the sale agreement by paying some advance sale consideration. Well, at some point in time after paying the sale consideration, if the allottee or if the consumer thinks that the developer is not sticking to the time stipulated under the sale agreement, if the developer is refusing to hand over the possession at the time as promised by him, if there is any delay, in obtaining necessary permissions, in obtaining the approvals that is requisite, that is important from any of the authority, be it including the municipal authorities, be it including the water supply and the drainage boards, be it the electricity boards, or it could be any other authority, including the RERA itself, right? So if there is any kind of delay on behalf of the developer, then there are certain rights that is provided under the Real Estate and Regulation Development Act of 2016, which basically provides a remedy for the customers or the allottees to approach the Real Estate Regulation and Development Authority, and also in addition to this, the consumer or the allottee can also approach the consumer forum, which I will discuss it in a little while. Well, coming back to the discussion on the rights of the allottees or the consumers. So he is, as a consumer, I am entitled to know. As a consumer, I am entitled to procure all the documents which the developer has obtained as permissions or the approvals, right? In addition to that, the allottee is also bound to know, the stage-wise completion of the projects and the amenities that as was promised by the developer. Further on, the Act clearly prescribes that any developer or the builder has to facilitate, which means as an allottee, as a consumer, I have a right to form an association, right? And this particular association is basically a welfare association, as you might have all been aware of the residential welfare associations being formed in different places. Well, if it's a single developer, there will be an association of consisting of all the owners, or it can also have the tenants basically who will have the possession of the apartment, who are living there in the particular premises on a day-to-day basis. So this formation of association is another thing which a consumer or an allottee is free to exercise and also create. But there cannot be multiple associations at the same time, and which is again a different legal issue which we don't want to venture into. In addition to these rights, the Section 19 also provides that if in case I as a consumer, I as an allottee would like to cancel the project, what is the remedy available? I definitely would like to seek my money refunded. I would definitely want my money to be refunded. But in most cases, and prior to the 2016 Act, what used to happen was that by citing some clause in the sale agreement, the developer used to refund probably only a partial amount of money, or there would be no refund at all. So in order to address this particular situation and this instance, the 2016 Act provided for the provision specifically with regard to claiming of refund in case there is any kind of cancellation. But this has to be a balanced approach wherein both the developer and the allottee will be placed on a position where they both don't suffer losses. Which means, suppose if I book an apartment today and I want to cancel it 3 or 4 years later on, the developer would have lost substantial amount of money, and the developer would have spent a lot of money on building and completing the project, which of course requires a lot of money, manpower and other things. So if in case after 3 years, if I go and seek for a refund, definitely there will be some kind of deductions, there will be some kind of amount which the developer will hold back. So only a partial amount will be refunded to the owner of the project and not the entire sum. So this is basically the issue, or these are basically the rights which has been prescribed under the Real Estate Regulation and Development Act of 2016. Further on, Now that we have only discussed about the rights, don't you think there should also be an obligation on the on part of the allottee or consumer? Indeed, Section 19 of the Act also clearly prescribes that there are certain obligations on the consumer or the allottee who basically books an apartment or a residential house out of his own intent. What are the duties and allottees? Once a person signs a sale agreement, he will be bound by the terms of the agreement unless it is blatantly arbitrary, unless it is blatantly unfair and one sided in favor of the developer. Only then it can be challenged, but otherwise, all other stipulations are to be followed, are to be mandatorily complied with by the consumer or the allottee. So, what are those clauses? If you refer to Section 19, there are clear clauses on this particular aspect which basically says that the allottee or the consumer is duty bound to pay all the charges, pay all the money that he is bound by the sale agreement. In addition to that, if the project requires any other expenses to be borne and which is required for the project, including the water, electricity, or it could be any form of taxes, the consumer or the allottee has to bear it no matter what. In addition to that, if in case he defaults, if in case a consumer defaults in making payments as per the schedule under the sale agreement, which is bound to happen in several cases for the simple reason that most of the people would be investing their hard-earned money, their life savings in a particular project, and it may definitely take some time for them to pay up the money as per the schedule. So, in mutual agreement with the developer, based on the discussions with the developer, the allottee can pay the amount unless it is delayed. He can seek for some kind of extension with the developer itself in making the payment. But if in case he delays further on, then he is liable to pay interest on the amount that is delayed. In addition to that, once the sale is completed, which means once the sale deed is executed, the allottee is duty bound to take the physical possession of the apartment or the residential project within the project as stipulated. It can be as per the agreement, but the Act says it has to be taken within a period of 2 months. In addition to that, the sale agreement, which ultimately results into the sale deed, right? That is the document which confers the title on the allottee, has to be executed, and any person, it could be the allottee himself or his representatives, must be present at the time of registration of this particular sale deed. So this is a mandatory obligation on part of the allottees which they will have to comply with. In addition to that, there are certain duties also. Now that we have spoken about the rights of the consumers, rights of the allottees, there are also certain duties on the promoter or the builder, who has to basically provide details about the project, not just to the individual or a person who is booking, but there is also duty towards the public which he has to comply with. So let me tell you what exactly Section 11 deals with. So if you refer to Section 11, you will see that there are multiple obligations on the developer or the promoter. In one is towards the public and other towards the individual, that is the allottee or the consumer who is booking the particular flat. So once he procures all the approvals, all the necessary permissions, the same has to be updated and the same registration details have to be mentioned in their respective websites or in the project location wherever it is happening. In addition to that, the promoter or the developer is also duty bound to maintain all the facilities or all the amenities that is provided to the project, which includes the common area facilities like the lighting, the lift area, or even the special amenities including the gymnasium, swimming pool, if there is a multi-purpose hall, so on and so forth. There are numerous things that are there. So the developer or the promoter has a duty to maintain all these amenities, essential amenities, until and unless the formation of the association takes place. Once the association is formed, the association consisting of the chairperson, secretary, president, vice president, members, so on and so forth, there will be numerous amount of people who are involved in the taking care of day-to-day business of the apartment. They will be handling these common facilities and all the issues related to the residential apartment project. So in addition to that, the promoter also has to take part in basically fulfilling the promises made under the sale agreement, that is the stipulations as under the sale agreement, including the promise of handing over the possession, timely promise, that is to execute the sale deed on a timely basis or as under the agreement. Further on, he also has to procure all the permissions from the municipal corporation, from the municipal authorities, from the water, sanitary, drainage, electricity, forest if required, waste, and the pollution control department, right? So these are some of the authorities which are basically are basically provided with the duty to issue necessary licenses and also approvals as and when required. So now that we have looked at the rights and the duties of the builder as well as the consumer or the allottee, if in case there is any dispute, which is bound to happen, which will happen, the disputes basically are of several nature. It can pertain to the amount of compensation. It can pertain to delay in handing over possession of the flat. It can pertain to non-formation of association or any other amenities as promised by the developer or the promoter. So when any issue pertaining to the developer or the pertaining to the residential project is faced by the consumer or the allottee, the first thing that has to be immediately done is to identify what type of issue is basically the allottee or the individual is facing. So once that is done, the immediate or the appropriate authority before which a complaint or a dispute may be instituted is ideally the real estate regulatory authority. So this real estate regulatory authority is formed under section 20, which basically consists of the bureaucrats, the former IAS, IPS, or it could be any of the union service officers. These are the three people, the honorable members of the authority. Basically, they will be adjudicating the disputes pertaining to delay compensation, pertaining to facilities, amenities, or if there is any violation or breach of the sale agreement. The real estate regulatory authority is the appropriate authority which basically deals with these types of issues. In addition to that, the Act also provides for what is called as an adjudicating officer. This adjudicating officer is the one who is in charge or who is duty bound to calculate the compensation as provided under section 71. If in case, after instituting the complaint in either of these two authorities, if there is any grievance, the appellate authority will lie before the real estate appellate tribunal. It is a tribunal constituted under section 43 of the Real Estate Regulation and Development Act, wherein any aggrieved person by an order of the real estate regulatory authority or by an order of the adjudicating officer may approach the real estate appellate tribunal seeking on the basis of an appeal as provided under section 43 of the Act. Well, there have been certain confusion with regard to which authority will basically have a jurisdiction. Now that we are on the aspect of specific law, discussing the law on real estate regulation and development, now that it has come into force in 2016, there are multiple cases that are also filed in the consumer forum. So if there is any confusion with regard to whether I should approach the RERA authority or whether I should approach the Consumer Protection Forum as provided under the Consumer Protection Act, this particular point has been clarified. This particular point has been clearly clarified by the Honorable Supreme Court of India in Imperial Structures versus Anil Patni and another, wherein the court held that the jurisdiction of the Real Estate Regulatory Authority or the Act itself does not clearly debar the Consumer Forum from entertaining any disputes. Well, if there are any disputes in the Consumer Forum which are already instituted or which may be instituted at a later point in time, it does not take away the jurisdiction of the Real Estate Regulatory Authority. Rather, it's a concurrent jurisdiction that both the authorities have and they can exercise. Well, there are certain specifications which comes into picture, wherein if there is any issue pertaining to the facilities, amenities that are not being provided, well, the ideal or the appropriate authority would be the Real Estate Regulatory Authority for most cases and for resolving most of the disputes. But when it comes to compensation and when it comes to certain breach of agreement, the Consumer Forum also has jurisdiction, and in several cases, the Consumer Forum has granted compensation to the home buyers or the allottees. Well, as an individual, how do I approach the Consumer Forum? Well, I feel as a consumer or an allottee, I have suffered enough with my developer because they have probably refused to hand over possession, they have not refunded my amount, or probably failed to deliver on the promises that they made with regard to the amenities. Well, it's an easy process where anybody can approach the Consumer Forum or also the Real Estate Regulatory Authority. The easiest way is to contact your lawyer, contact your legal advisor with regard to the appropriate jurisdiction and filing of the complaint. However, if the individual wants to do it himself, all by himself, well, each of the state has got its own Real Estate Regulatory Authority, and for the purpose for our state, we have what is called as the RERA Karnataka, right? K-RERA, wherein as you can also see on the screen, you can file the complaint by following the process as given in this particular handbook or a manual. It's a very simple process. It starts from this particular aspect where you just have to enter the website, log in your key details, and also you can start by there are multiple options in the website itself wherein you can choose the appropriate grievance that you have suffered, and based on that you can write a brief narration about the issue that the individual or the home buyer has suffered. So this is basically the handbook, and this is the process in which one individual can approach the Real Estate Regulatory Authority for filing the complaint or any grievance that he has suffered. So with this, I'll conclude my discussion on the real estate and consumer rights. Thank you so much.